sure that the prosecutor, the office of prosecutor, the position of prosecutor, that actor identified here as a prosecutor, is as insulated as possible, as far as possible, from undue influence coming from any source, be it private interest source, corporate interest sources, political players and actors. I believe in the interest of justice, we've got to go as far as possible to make sure that the prosecutor is insulated from any undue and unwanted, undesirable influence from any source whatsoever. I think that is absolutely critical. The other thing I think is very critical is the capacity of the court to quickly expedite these matters, because the court is involved in the establishment of the agreement, confirming that. The court is involved in adjustments or amendments, wavering of the agreement. The court is involved in termination of the agreement. The court is critically involved in this. We have already in Barbados a problem with the capacity of the justice system at the level of the court to expedite matters. And I think the attempt is being made here to expedite the dispensing of justice by, rather than have some cases embroiled in long, drawn-out criminal proceedings, to come to a remediation agreement which is set in place in the context of clearly established parameters involving the expression and will of the court, the role of the prosecutor, properly insulated from that undue influence, and the willingness of an offender to admit to his offense and to be willing to identify others who were party to that offense and be willing to go the other steps in terms of ensuring that justice is properly dispensed in the interest of all parties. Those are 2 or 3 considerations I would want to put in the mix. And I hope that that does not constitute naysaying or gainsaying.
I member for St. George.
Mr. Speaker, let me thank the Honorable Leader of the Opposition for his support for this bill. I welcome his comments, but I am able to give him the assurance, sir, that the prosecutor in this context will have the benefit, sir, of the independence that is required in order for him to be able to discharge his responsibility. Let me say, sir, that part of what is going to happen, and we've already discussed it with the Chamber during our estimates process, especially in relation to the area of corruption. A new agency is going to be established so that issues of corruption, past, present, if any, and future, if any, come, would be investigated by a specialist team of individuals, and to the extent that those individuals may constitute the prosecutors in that instance, they too, sir, will have the independent protection of the law. With those words, sir, I beg to move that this bill be read a second time.
Question is that this bill be read a second time. All those honorable members in favor, please say aye. Those against, please say no. Meeting, the ayes have it.
Mr. Speaker, I beg to move that you do now leave the chair and that this House resolve itself into committee for further consideration of this bill.
Question is that the Speaker do not leave the chair and the House resolve itself into committee for further consideration of this bill. All those honorable members in favor, please say aye. Those against, please say no. Meeting, the ayes have it.
This House is now in committee.
Clause 1.
Beg to move, Madam Chair, that Clause 1 stand par.
The question is that Clause 1 stand par. All honorable members in favor, please say aye. All those against, please say nay. Methinks the ayes have it.
Clause 2.
Madam Chair, I wish to propose an amendment to Clause 2, and I need to offer an explanation to the Chamber. In the definition section, Madam Chairman, prosecutor is defined as including, as meaning the Director of Public Prosecutions, a creature well known to law and well known to all of us. And then it goes on, or the Director General of the major organized crime, anti-corruption, anti-terrorism agency established by Section 4 of Major Organized Crime, Anti-Corruption, Anti-Terrorism Act of 2020, as the case may be. Mr. Speaker, Madam Chairman, you'd be aware that we are bringing a suite of legislation to deal with corruption and other matters. Unfortunately, the bill referred to here has not yet been laid and therefore has not yet passed this chamber. We've had to do some more work on it, and we are almost nearing completion, and we had hoped, Madam Chair, to have it here. But in view of the fact that it is not yet in this chamber, it is not a thing in essay, not a thing in existence. And therefore, I want to amend this particular definition by saying simply prosecutor means the Director of Public Prosecutions. I serve notice to the chamber that when the specific legislation is enacted, we will by that enactment add on here the Director General of that agency, but I'd rather go through now and add to it by way of an amendment in the not too distant future. So I'm asking then that the words after Director of Public Prosecutions be struck from the bill.
Question is that clause 2 stand part with amendment. All honorable members in favor, please say aye.
Aye.
All those against, please say nay. I think the ayes have it.
Clause 3 to...
Clauses 3 to 10.
Beg to move that clauses 3 to 10 stand part.
Question is that clauses 3 to 10 stand part. All honorable members in favor, please say aye. All those against, please say nay. Methinks the ayes have it.
Clauses 11 to 15.
Beg to